Hey, EB.
Hey, how's it going?
Yeah, good, thank you. I'm just switching devices, so
No problem. Is it getting to be spring there now?
it's summer. It's hot.
Well, it's starting to get cold here, but I heard a saying the other day and they said it was Australian and they said it's just apples. So I don't know if you know that saying or not, but it's kind of funny.
Apples. Is it like saying apples and oranges? Is that from that
I
saying?
think it means just peachy, but it's like, oh, it's just apples.
Oh,
It's
right.
apples.
Yeah,
Yeah. Instead of peachy or peaches, yeah.
yeah. Okay, I'm gonna switch devices.
What happened? Fuck, every time, man,
What's
every time I turn
happening?
around, somebody's saying something. Shit. We didn't get to chapter 2. I don't understand what's happening.
What's that for?
I gotta get out of fucking Telegram because every time I turn around, somebody's saying something. Like,
Oh,
just
yeah.
something. Like, there's always like a chime or something. And I'm like, this is all pointless. Where's Raina?
Yeah, I'm not sure. She hasn't responded to
Jesus Lord. All right. Ah,
Oh.
I don't know what the hell this motherfucker's talking about. Man, I'm in a bad mood again right now. I don't know why. But not as much as yesterday though. That's a fact.
Hmm. Like my my
Hmm?
background, my virtual background.
In class. Yeah, I'm in class. Yeah. I'm in class. Yeah, I'll call you in a bit. God, man, my fucking goddamn speaker. Speak. Triple, speak. Speak. Yeah, I love it. Speak.
Yeah. Can you hear me?
There we go. Yes. At least, fuck. It's because every time they call, it turns into like, pawn check in, blah, 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 blah. They all know my schedule, blah, blah, blah. It's not an emergency.
All right.
Thank you.
That's your coffee?
Yeah, I got coffee. I need that. What you call it? You got it wrong up on there. You cannot have spaces in between the asset. That means it's one word. Smooth operational law altogether is the correct way to put it.
Okay, I'll change it.
But I do like the background. Where'd you make it? Canva?
Of course.
Yeah, I was thinking of doing one. You should send me a copy.
I will.
And that just be the thing for everybody.
We'll do.
Everybody that's on staff, on team. I need you to also make sure that we get that fucking goddamn. Hey, we're gonna show them that pleadings today. We're gonna talk about it. Can't even hear you.
Yeah, you want me to pull it up?
Yeah, we're gonna do it. And then not only am I gonna go through that shit, but here's the other thing. I'm gonna preface it with there's a Texas case. I obviously got the goddamn fucking documentation for that in an article file. We're not gonna do it here. I'm just gonna give them the synopsis and game.
See new stuff tomorrow.
Sending new stuff tomorrow? Who? Me?
TV.
To me? Yes. What? Oh, okay. She's talking to me. I got it.
Yeah.
Oh, I got it.
Yeah.
So my point is this. I'm gonna preface the shit. I got you. Roger. So I'm gonna fucking sit here and I'm gonna preface it with why the fuck I don't do the civil side, but we're gonna show them the civil side because it is viable.
Yeah.
All right, we'll do it. Yes. That's not the fucking one I want, clown. Visual. Dead. There we go. There we go. See it? Now you can't see it.
All right. No, I'm in.
There's
I'm
the
in
app.
Canva.
There's the app for the advanced class so that everybody could get it. Free, obviously, no subscription, not charging.
Awesome. Okay.
Hey, watch this shit though. Watch this shit.
Hang on, switching over. Yeah.
What's that? What's that?
It's your website.
Yeah, but hold on. Look, it's on an app.
Yeah.
So they're gonna get that shit.
Amazing.
That's what all the fucking programmer was doing. Where are y'all? You know what I mean? Sitting there day in and day out, getting it, so that they can have the access to it with all those files that we're about to show them, and then they could sit there and then again say that they didn't get the secret squirrel stuff because the articles that we've been writing, that I've been writing, right? They're highly technical. Highly technical. And it doesn't sound like Raymond speak.
Okay, it doesn't look like it, but it is. It has no spaces. Okay. So I'll send that to you. But I
We'll fix it.
open.
We'll fix it. All the dimensions, so that it kind of looks rational, but in a bit. But it just can't have the spaces.
Yeah. Okay.
I'll work on it.
You want me to open?
It looks disgusting like that too. It looks nasty. I don't even like it. I liked it the way you had it, but it's the truth.
Yeah, I know. I am just gonna go into. I gotta grab that link. Let me just grab that link.
Be respectful, trustees. I put that. Hey, that whole shit is fucking quiet. So there's like the front page, right, that civilians can go through, and then the entire website downloaded into the app along with other attributes of class, so that they're looking at the updates, having full gain to that, as well as that, and then anything that happens, I can just terminate. Just terminate.
So am I saying I'm going down to section, the third section, right? Section 3.
Yeah, we're gonna talk about that.
Okay.
In section 2, I put the common law way of claiming. Does that make sense? So those are the rules appropriate for common law.
Yep.
And then we get into what's appropriate for registry.
Man. Okay. Will you let me know when you want me to pull it up?
I'm ready.
Okay, let's go.
Okay, I'm moving the screen over. So
I'm down to 3. You let me know if you want me to.
all right. Kill screen. I just had to change a heart.
Yeah.
Because remember I said I had a preface. There goes everybody. All right. Yeah, everybody's a fucking like ninja. No cameras, can't see shit. Me and Tupo. Phantom. So here's the deal. Why do we choose arbitration over civil litigation?
More expeditious.
It's quicker.
Or what? Quicker.
It's expeditious.
That's it. Quicker.
Yeah.
And right, expeditious. It's expeditious. Yep. The other reason why is because certain facts that are discussed in the public in a federal district court have implications towards policy. And sometimes the individuals that are sitting in the chair, i.e., the goddamn judge, they might have prejudicial takes on the implementation of such a thing. And even if they are supposed to employ it, their policy beliefs may not align with what was already adjudicated. Does that make sense?
Absolutely, Raymond. Plus,
Okay.
as far as being able to bring in his documents only, you won't be able to do that in a regular court, would you?
That's right. And then you allow for the ability of the government to argue parole evidence. Does that make sense?
Yep.
Good.
Yep.
What is parole evidence? Let's listen to chat. Stand by for shock. Holy shit. What is parole evidence in a court?
Parole evidence that are not included in the final written contract are usually not.
Stand by. Can you please repeat that again?
Of course. Could you please clarify what you'd like me to repeat?
What is parole evidence in a court?
Parole evidence refers to information that isn't included in a written contract. In court, this usually involves verbal agreements or understandings that aren't captured in the contract's text. The parole evidence rule generally prevents parties from using this kind of evidence to contradict, modify, or add to the terms of a written contract. However, there are exceptions, like clarifying ambiguities or proving issues like fraud or mistake.
Thank you. Hey, if a contract is to be enforceable, the only way that it can be enforced is how?
A licensing agreement that you put in there is how we enforce it?
No, that's not my question. You just sounded like a Democrat.
Okay. I thought you
All right,
said,
so-
how do we enforce our contract? It's binding by
So
a
here's the deal.
non-signatory.
That's what I said. I said that if a contract were to be written and enforced, it would have to be
Legal.
presented as how? No, presented as right, legal, legitimate, which means that
Yeah.
the government would have had to already have had either the context of the context, huh? The context of that context already
Through contract
established.
law.
Adjudicate, right? It falls under contract law. So the
Right.
contract itself has to already have been seen as something that is viable, which means that now you are dealing with either case law precedents on the initiation of said construct of the agreement, or you are dealing with some sort of statutory provision that is not silent on the matter. Does that make sense?
It does. You can look the shit up.
If the government is silent on the matter, I'm telling you right now, don't fucking put it in your contract, because now you are going into novel legal theory. Does that make sense?
Okay. So you said not put
That
it
is
in there
where,
if the government silent.
stop. That is where the government can take a position of non-enforceability. Does that make sense?
It does.
When you're in the United States practice what type of sovereign immunity? No sovereign immunity?
Oh.
Absolute sovereign immunity? Or restrictive sovereign immunity?
Ooh.
That's a good question. I would have to go with
What is restrictive sovereign immunity, and why does the United States take that stance?
Restrictive sovereign immunity is a legal doctrine which holds that a foreign state is immune from being sued in the courts of another country, except in cases involving certain types of activities. This stance is mostly taken in matters related to commercial activities or transactions. The United States adopts this stance because it respects the sovereignty of other nations. This approach also reflects a balance. It protects foreign states from being sued over their sovereign acts, while allowing legal action in cases where they engage in commercial activities, similar to private entities. This balance is seen as a way to maintain diplomatic relations while ensuring accountability in international commerce. Would you like to know more about how this principle is applied in U.S. law or in specific cases?
Yes. What type of sovereign immunity does the United States practice when it undergoes tort claim actions against it?
In tort claim actions against it, the United States practices a modified form of sovereign immunity, primarily governed by the Federal Tort Claims Act, FTCA. Under the FTCA, the U.S. waives its sovereign immunity for certain types of torts committed by federal employees within the scope of their employment. However, this waiver is not absolute. The FTCA includes exceptions where the U.S. retains its immunity. For instance, claims arising from combatant activities during wartime, or claims related to discretionary functions, decisions made by a government employee that involve judgment or choice, are not covered. This means individuals cannot sue the U.S. government for such actions. This approach reflects a balance, allowing citizens to seek redress for certain torts while protecting the government's ability to perform essential functions without the threat of constant litigation. Are there specific aspects of the FTCA or its application that you're interested in?
What is the waiver of sovereign immunity when it is engaged in a licensing agreement for trademark?
When the United States government engages in a licensing agreement for a trademark, it essentially waives its sovereign immunity to a certain extent. This waiver is specific to the activities covered under the licensing agreement. In a trademark licensing agreement, the government acts more like a private entity rather than a sovereign. This means if there are disputes arising from this agreement, such as issues related to the infringement or validity of the trademark, the government can be sued in the same manner as a private party. This waiver is consistent with the principle of the government being subject to the laws it enforces on others in commercial activities. It's important to note that this waiver is limited to the scope of the commercial activity, here, the trademark licensing, and does not extend to the government's sovereign activities. Does this clarify your question, or is there a specific aspect of trademark licensing and sovereign immunity you'd like to delve into more?
Can you give me a course template based on what I just asked you? Now I'm going to say it again. In normal English, the government only waives its immunity when you bind them up to the terms of the contract, which is why we cover the litany of bullshit that we cover. Example. Texas had a case, 2020, with a trust in which the beneficiaries sued the trustee. In their arbitration clause, they never specified that the arbiters of the AAA were going to be the sole discretionary party over the matters of arbitrability of the contract. All they did was put a clause, like you see on most licensing agreements in the terms and conditions sections as you see them on the internet. Period. So which means that what you're getting in this class is a lot more extensive in psyche than lawyers normally agree to in their own common day practices, because they just don't test the waters like that. They just do business as business. And they usually will subject themselves to the court because they're fighting for your contract, not for their ability to construct a contract. See, if they wrote it for themselves, then it would have a different enforcement level. But if they're writing it for someone else, then it depends on what the needs are. And if they're just enforcing an agreement, then they can only battle up to the terms and conditions of said agreement. Does that make sense?
Yep.
Good. So then that means that we have expeditiousness. We have that the fact that we term the contract in such a way that is what the United States or any state will waive their sovereign immunity up to. And therefore we must be scientists when we are fucking creating this little technology of a contract. Because if we don't state it on the instrument's face, we remain faceless of a claim. Does that make sense?
Yep.
Or have no face to make one.
Yes.
Yep.
Makes sense, right? Okay. So with that being said, Chupo, can you put
Yeah.
with can you put the sheet up?
You want me to go to section?
Right. Section 3. Yep, there we go. So this is trademark infringement. Okay, I wrote this, obviously. This is a template. One of the things, in order for us to even actuate this suit, what must we send to the government in order to have at least some viability to a claim and have a likelihood of success?
Well, cease and desist. The license agreement.
Why should we send a cease and desist? Let's stop there.
Because once they receive that and they continue, it's a willful infringement.
You're putting the
That's
other
right.
party
And
on
one of the
notice.
parties pursuant to which case?
Alan v. Cooper.
Alan v. Cooper. So Alan v. Cooper, in that case, the plaintiff failed against the government. Does that make sense? Or against that corporation, sovereign entity, whatever you want to call it.
Yep.
Failed in that case. And then comes the reason why. Because it wasn't willful, or they didn't prove not enough adequate state remedy. Which are the keys to why we would have a likelihood of success. Does that make sense?
Yep.
How long have I been doing this? I've been doing it since
10 years.
10 years?
2013, late 2012, 2013.
Okay.
Be advised. How many cases do you think went in kind of like this, very close, but no cease and desist was sent, and therefore the discretion of the court was to uphold the system?
Absolutely.
They failed a lot.
Probably why you
It's a
people hear people out here saying, "Oh, that trademark stuff don't work." No, they don't even hear it. That's probably why.
What is the missing prong then?
Would
they
be
don't
the
send the
cease
what?
and desist with the licensing
That's it.
agreement,
That's exactly it.
which binds them as a non-signatory.
No, well, hold on. We're going to get just into civil litigation. Let's take out arbitration completely from the equation and let's just look at it. No licensing agreement just for right now. Let's look at it just in the eyes of cease and desist for the next 30 seconds.
Okay.
This document is not taking you to arbitration. I am showing you the civil litigation side first. And yes, this document does come with the argument for a licensing agreement, but we're just going to keep it in federal court as a civil suit to just entertain that idea, even though we know that we're smarter than that. We're going to go to licensing and fulfill the licensing with an arbitration clause to bind them as a non-signatory. Does that make sense?
Okay, right on. This is the foundation of it. Right on. Cool.
Right. So this is the entire argument scope that you would even put into the damages at arbitration instead of putting it in this toilet. But in this toilet of federal court, it still is viable. Does that make sense?
Absolutely.
So then arbitration is only containing the amount of time and not allowing parole evidence or any other discretion. It takes away discretionary act capability because they're bound to the terms and now they're operating as a private entity. So one, introduction, plaintiff, Raymond De Leon is trustee of the De Leon Intellectual Property Trust, a real party in interest in FRCP 17A, accuses defendants of trademark infringement and unfair competition and related claims under 15 U.S.C. 1122, 15 U.S.C. 1114, 15 U.S.C. 1125A, 15 U.S.C. 1125, 15 U.S.C. 1122. I don't know why he says that twice. Okay, that's a typo. That one, the 15 U.S.C. 1122. There's supposed to be a 15 U.S.C. 1127. So that means that you changed it.
Right at the end.
Oh, no, it's not. No, it's there. 15 U.S.C. 1127. So I don't know why he says it twice. But let's leave it there. Leave it there. Let me handle that. Don't touch the document. Let me handle it. Yep. Plaintiff claims ownership of a well-known trademark, your name, right? Your name, TM, which has been in use for over however long, and if it's not years, which has been in use and has commercially established itself with the USPTO. Why are we using a federal trademark here instead of a common law trademark? Because first you need to understand what on the books meaning with their registration they're bound for it. The document that it would take to make a common law trademark pleading is a little bit more extensive. And I needed to give you guys a fast rap sheet. I did this last night. Does that make sense? If you have a question about how the functions of a common law trademark should look and what statutes would apply, Chupo, can you scroll to 2? The entire fucking section before it is for common law. Does that make sense?
Yep.
Good. Go down, Chupo. So you would just modify this according to those statutes.
Okay.
Parties, me, defendants, them, and defendant B, the agents plus subcontractors. 3, jurisdiction and venue. Pled. Okay? We got fucking shooter shit, 1331. We got all that crap. Go down. I should put in the substantive law, fucking prong, but it doesn't matter because it's all licensed. So here's the deal: the plaintiff, with a history dating back to date, has established itself as a trusted entity built on the foundation principles of integrity, quality, unwavering commitment, and relentless innovation. Trademark a symbol deeply rooted in the plaintiff's heritage, right? Because it does come from our family, and you can say that. Embodies the essence of the plaintiff's dedication to providing high-quality products and services. We're going to stop there. Chupo, kill screen. What services do we do?
Good and a service.
Huh?
We provide both a good and a service. They
What
wear
is
the
the
t-shirt.
service? What is the service?
Apparel service.
Huh?
Apparel.
It's a wear. Well, go ahead.
No.
Answer.
No.
We're doing a t-shirt, which it
Yeah, that is
It's
a
apparel.
product
wear it.
that provides a good and service, but we, as trustees, have a specific function that makes them direct competitors regarding that mark. See, we put it on t-shirts to provide a product in that arena, but the entire scope of what our job is that falls in direct competition with the state actors is what?
We have a
The
fiduciary
management-
duty to the trust as the trustee.
The management of the trademark to expand it into all competing markets.
Oh, okay.
That is
Right.
the mission statement that should exist on your page. So that when you
Right.
bring it in as internet evidence, it then becomes that you have a reasonable expectancy to expand into all conflicting markets. So whatever they do and how they choose to move proves that I already
That's
had a
fucking
trajectory,
brilliant.
so no matter what they did, I'm covered. Does that make sense?
That's
Yes.
fucking brilliant, dude. My gosh. That's a bomb.
I don't fucking like to lose. Does that make sense?
Yep.
I will fucking burn a village just to not lose. Does that make sense?
Yes, sir.
Yes.
That's amazing.
I've been shot 3
That-
times. I'm a very weird guy to talk to, and I like it. I love it. I embrace it. That's why it's me. So I have to think as a warrior. I cannot think like a civilian. That means that I need intel. Intel would be, can I gain as much information as I can about the battlefield so I can make a battle plan? So any evolving situation that I need to adapt to, when they kill one form of kill train, I have another answer that falls into the slot mosaically. Does that make
Yeah, man.
sense?
Yep.
Oh yeah, you got it covered before they even move. They got nowhere to move. That's like a checkmate. Absolutely.
Right. So when I'm having that shit on the website, I have the omnipotence of God. Does that make sense? That it would be everywhere at once and nowhere at all. But it's there to act. If my mission statement is that broad, and that is the sole purpose of me as a trustee, to defend it and proliferate it and restrict all other competition, and that is my mission. And there is evidence self-authenticating on the internet. Stand by. Let's pause right there. In federal court, what is the federal rule of evidence that states that internet evidence is self-authenticating? FRE 902, subsection 14.
The federal rule of evidence that addresses the self-authentication of certain types of internet evidence is Rule 902.14. This rule states that evidence generated by an electronic process or system that produces an accurate result, like data copied from an electronic device, storage medium, or file, is self-authenticating. This means it does not require extrinsic evidence of authenticity as a condition for its admissibility. This rule can apply to various forms of internet evidence, but it's important to note that specific requirements must be met for the evidence to be considered self-authenticating under this rule.
So the way that we got domains, like for example, smoothoperationoflaw.website, is that they're the highest form of domains. I don't have a subset domain. Does that make sense?
Yep.
Yeah.
So then that means that if it's up there and it's on that level, UDRP would respond. And then they're going to look at the dating. And I win. Does that make sense?
Yep.
Absolutely.
Yeah.
Now, what kind of proof do they ask for that? Is that in that motion
You
I
put
was
in
doing?
the URL and you put it in as an exhibit, and they can duplicate it. They'll just go to a bathroom, take a shit. Yeah, it's up there. Yeah, that's his mission. All competing markets. That's it. It's about the intent. That's all it is. How smart are you to state the statement that conjures up the representative market's ability to expand into different competing markets, and any one of those markets is competition against your mission? That in itself is omnipotent.
Yeah, man.
Make sense? Okay.
It does.
FRE 902.14. Okay. Let's go back to that screen real quick.
Sorry.
Section 3.
Section 3, yep. You want me to go down?
Yeah, where we're at. All right, so I'm going to move down to where your cursor is, right under it. In pursuit of mutually beneficial partnership, the plaintiff entered into licensing agreement with various companies, one of which defendant A granting them the privilege to utilize. So that means that you do business with different businesses, and one of those things, so this is your natural course of business, licensing agreements, right? And then defendant A, who's defendant A?
Government.
The government. The privilege to utilize it on authorized products. What type of production do they need to give us? The service of destroying. And what they produce there should be like a note of confirmation. Does that make sense? Yes or no?
Yeah.
Yep.
So, what allows for a government entity to remove a case without getting destroyed as a result?
NDA.
It is no, sua sponte.
Sua sponte.
Sua sponte. What does sua sponte mean?
Sua sponte. In law, sua sponte or sua motu
On its own motion.
motion describes an act of authority taken without formal prompting from another party.
So that means they can Lego my ego at will. Does that make sense?
Hmm.
Can the government relieve you from the liability of a case sua sponte? Yes or no?
Yes. Yes.
Good. Are we clear that the mode, leave it there. Are we clear that the mode, leave it there. Are we clear that the mode of our licensing agreement? Hey, send me a fucking copy of that when you get a chance. What is that? That's
Oral evidence.
yeah, but where are
What
you
we-
getting that?
Um.
Send me a copy of that
Okay.
once you get a chance. Just because it's pretty simple. All right, so here's the deal. So the bottom line is this. I have to turn the screen on because when you move, it gives me like a fucking strobe light. I'll get back to you.
Sorry.
Yeah, it's not your fault. It's me. Is this? Apps accessing content in this meeting? I don't care about that. Oh, there it is. All right, so here's the deal. So sponte. The government's own prompting, it could say, yo, I don't want to take this case. And we should leave it alone because it has implications that will cause some form of shit that we won't be able to escape it. How about that? We won't be able to escape it unless we kill him. Does that make sense?
Hmm.
Does that make sense? Or do I sound like an idiot? Should I elaborate?
Yes.
If we only construct contracts that have the complete totality of enforceability as it exists in your cease and desist, be advised, because obviously I made it and took all this into consideration. So either trust me or trust nothing. Then I've already looked at their top-down order on what would be enforceable. It's not left to them. Back to the case of the trust. Here's what happened in Texas. They went to court. Beneficiary tried to sue the trustees. The trustee said, wait, we have an arbitration clause inside of our indenture. The judge said, okay, I see it. But solely putting the AAA and not putting specific language, a binding of a non-signatory, because the beneficiary isn't a signatory, does not allow me to send it to AAA. Oh, no. Oh, no. You have to put that specific language in there for me to observe it in the contract. And what you're giving me is parole evidence. And they took it and slammed them. Trustees failed. Now, who does that fall under? The grantor, right? Because the grantor never thought about the protections of his trustees. Yes or no?
Yes.
Yep.
Because he was dumb. How about that? Smart enough to to do estate planning, yet stupid enough to fuck up the provisions of his individuals.
Hmm.
Does that make sense? Well, he was thinking about the beneficiary. You guys would never fall into that in devising a trust, because what type of clause do we have in the trust that would mute that beneficiary the minute they tried to take action? Irrespective if we had an arbitration clause or not.
No contest clause.
No contest clause. This is why you're in the advanced class. Because you guys are advanced. Does that make sense?
Yeah, man.
Yeah, but can't the trust protector help with that too?
They could, but there was no trust protector in the suit.
Okay.
So I'm not going to make up elements. But yes, the trust protector could. This is a fact. Trust protector, one line of defense. To keep internal matters out of court. No contest clause on its own. Mutes the beneficiary, they never get anything. If they contest. It's good and it's bad. To put them in or out, it depends on what your scenario is. I don't like whiny babies. And the way I see it in life, most of the time beneficiaries are idiots. Why do I say that?
They're ungrateful, man.
Usually, right?
Yep.
You have family that will sit there and fuck you up your. No? And it's all because they want more. It's all because they want more. They all want more. They just want more. They want more. They want more. Let me say it again. They want more. But at the same time, if you're in here, you have kids, aren't you supposed to make this cult-like behavior within your family? Meaning that they too would know their positioning within the trust and know that it's to no avail and never bring that war because there is no likelihood of success to begin with. Unless they're going to kill their own family.
Spell it out for them, huh?
And the percentages don't change. But nonetheless, the percentage is more if there's more to take from. That's an option. I wouldn't suggest it. Does that make sense?
Yep.
A lot of people will do a lot of nefarious shit in the courtroom for one simple reason. Because they don't feel like it's real because they never killed them. If you told a lot of people, oh shit, they hit you and you can't call cops, then go get that. What do you think they start to act like? It's not worth my fight. For example, Raymond wouldn't want to go fight the cartel. I'd rather take a plane ticket to some long distance place where they can't find me. Does that make sense?
Oh, yeah.
You know, everybody knows what wars they can win and what wars they can't. So the system allows for a level of parity. But in that system, people do a lot of heinous things, making false fucking claims that don't exist. And given the circumstance of people's mind and whatever the hell they're into, it can lead to certain adjudications that often are fucking bogus from the initial. Like false allegations, blah, 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 so on and so forth. My point is that a contract takes that away. There is no such thing as, I'm a prosecutor from the United States, and I should be able to admonish. No, you're private. This is private. Private. The arbiters will check the arbitrability. We as the federal government do not have the authority at this point. It's out of our hands. Does that make sense?
Yep.
And so in that aspect, our arbitration clauses designate the arbiters as the party to check arbitrability. Does that make sense?
Yep.
We don't make those fucking mistakes. Well, I'm not an idiot. I play to win. What will I do to win? Burn a village. Whole fucking village up in smoke.
Scorched earth.
Scorched earth. That's right. And so with that being said, that I give to you. A scorched earth understanding of how to employ the proper modes to take away power from the government. In this civil complaint, there are the right parameters just in their court to smoke them. Yet you guys are aware of an extra step that completely silences everything forevermore, which makes it that much more potent. It would be the equivalent of having both trust protectors and a no contest clause to shield the trustees from wasteful litigation. Does that make sense?
Yep.
Cool. We're going to stop there, but we're going to review. We're going to scroll down so that you can see what other itemized stuff, just in case I get an impulse. Let's look at that screen. Yep. Okay, scroll down slowly. Now, the constitutional provisions, be advised. That is selective if you are going to go against the federal government and you wanted to do a tort claims because you must prove Bivens. So if you were to try to do an FTCA over trademark infringement and property rights on its own, that exists there for just consumption. But that would be taken out because you are not going there for tort claim. You are going there for contract breach. Go down. Here are your statutes. That's how it's supposed to look up there. So that's why I said there's an extra one, 22. Okay, 1122. Go down.
Are we going to get a copy of this, Rabbit?
Hold on. Yes.
Thank you.
Relief requesting. Whoa, God. Why does it just say recall and destruction of infringing products? It is supposed to be more expansive there. I don't know why it says that. Tubo, is this your version?
No.
Good. Then that means it all falls on me. It's not supposed to look like that. It says recall and destruction of infringing products and data and stuff like that. I specified it. So now I have to change that because I did it last night.
No, I did
remember
see that. I did see that, but I think maybe it's up in section 2. Should we have a look?
Go. No. It's not in section 2.
No?
No, it's not. It's supposed to be tied to that. Go up. Go up. Yeah. And then we have the conclusion. Go down. Make sense? Okay. Kill screen. Free flow starts now. Now, the
Raymond,
section after that goes
Raymond,
into each one of the statutory counts. Hold on. And contextualizes what 1114 is, what 1115 is. And it goes down and it expresses it completely. That make sense?
Yeah. What you laid out there was a lot more direct and simplistic and organized compared to the claim form I've been dealing with, to be quite honest about it, because they had a lot of extra crap about bankruptcy and everything else in that claim form, right? So that's why
you asked me yesterday, right? In text, what you asked me. I said yes. Bang. There's your answer. Did this answer your question?
Some of it, yes, but there's other things that are highlighted that are still unknown, like they asked for an indenture number. They asked for a copy of the date the URL was filed, stuff like that,
all this shit, you got all this shit, you have to, this is a fact. Does that make sense?
I'll look at it. Okay.
Yeah, because they want to know how valid are you and who are you?
Right.
And you can tell them. You can tell them, my job is only the security interests involving the intellectual property. And you have to be smart enough to say that.
Okay.
You have to be smart enough to say that. But this is why we go through breach of contract in arbitration, so that they just see the law and don't start doing all this. Make sense?
Yep.
We will go through a DK. When are you ready?
All right.
Don't say anything, because we're in class. Can't do it. Be recorded.
Hey, still recording?
No, yeah, we are. But no, leave there. Just we're in class because I can't I can't
Yeah,
because that's a whole other.
I understand. I understand.
When do you want to do it?
As soon as possible.
When do you want to do it? Besides right
We can do
now.
it tonight. We can do it tonight if you want.
All right. Let me, because I got to eat something.
Tonight or tomorrow, whatever's good for you.
Tonight and tomorrow. So I'll call you probably if I don't call you by 10, then
Okay.
tomorrow. Right. And then
All
tomorrow probably like at 7. Because I don't
Perfect.
have shit to do.
Perfect.
Did we learn anything?
Oh yeah. Holy
Yep.
shit.
Yeah, good stuff.
No complaints here, dude. Fucking amazing.
Then that concludes this right now. Tupo, this is a product. Do I have consent of everybody?
Yep.
Oh yeah.
Anybody protest? Answer now.
No.
I'm
No.
going to take this video and you already know what I'm going to do. I'm going to make it a product for expose.
Awesome.
Because there's a lot of punk bitch motherfuckers out there on earth that
Oh
I need
yeah.
to punch in the fucking mouth. Do you know what I mean? Because sometimes a guru may think that they know something. They don't know shit. They can't even tell you half of the shit that I told you guys tonight.
Mhm.
They're
I know
disgusting.
you're right.
They're disgusting. They're disgusting. I'm putting this on
They
camera.
are.
They're disgusting. They're so disgusting. They're not disgusting for being stupid, but they're disgusting for remaining stupid when they came across me, and I whoop their asses every time that they speak to me.
And they're dishonorable as fuck. It was really fucked up intent. But that's a story for another day. You were talking about the video there. Are
You've seen
they
them?
gonna?
Hey, Alan, you've seen them.
Oh yeah.
I've been
I got them
quiet for
pissed
a
at
little
me
bit.
right now. Oh yeah, I
Hey,
got
I'm
them
gonna
pissed at me
fucking
right now.
give you shit. You've seen them?
Yeah.
So I'm gonna go ahead and punch him in the fucking uterus. All these dudes, I'm gonna punch him in the uterus.
That's funny shit, man.
Dude. Yeah. Disgusting. Disgusting. Fucking disgusting. The most
I want you to
disgusting
shut
thing I
right the
do.
fuck up, man. I'll tell you what. I told you why I got involved with your first class
We
when
can't
I
talk
met
too much.
you.
We can't talk too much. Hey, we can't talk too much. But I just wanted to put
Okay.
that on camera. All right, let's kill the camera.
Yeah. Got you. Sorry. Got you.
Then we could talk.
Yeah.
Do you want me to kill the camera?
Yep.
Recording? Okay.